remedies are subject. Enforcement of fundamental right. The Indian Constitution has not only declared the fundamental rights but also provides effective machinery to enforce them. Article 32 of the Constitution gives real color and te- teeth to the fundamental right. Article 32 gives certain powers to the Supreme Court and keeps the door open for the Parliament to confer similar powers on other courts also to enforce these rights. It guarantees the right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental right. The right to such move for the enforcement enjoyed of such right has itself been enacted into fundamental right. The following remedies are provided by Article 32. Right to move the Supreme Court by appropriate proceeding for enforcement of the fundamental right is guaranteed. Appropriate proceeding under this clause has reference to Article 32 Clause 2, and that is a proceeding which invokes the writ jurisdiction of the Supreme Court. Supreme Court shall have power to issue direction, orders or writ, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, which may be appropriate for enforcement of any of the fundamental rights. Habeas corpus, mandamus, prohibition, quo warranto and certiorari. Without prejudice to the powers conferred on the Supreme Court, the Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. The right guaranteed by this article shall not be suspended otherwise as provided for this Constitution. Notwithstanding anything contained in Article 32, every High Court shall have power throughout the territory in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within this territory, direction, orders or writs, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them for enforcement of any of the rights conferred by Part 3 and any for any other purpose. Article 226 Clause 1. The power conferred on the High Court by Clause 1 shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of Article 32. Article 226 Clause 2. In Rupa Ashok Hurra vs. Ashok Hurra EIR 2002 C 1771, the Supreme Court has held that in order to rectify gross miscarriage of justice, it can review its final order, although it cannot allow the final order under Article 32 to be challenged again, as after it has also rejected a review petition against it. Court has given this type of petition the name of curative petition. However, he had imposed certain conditions before such a petition can be filed. Further, the petitioner will have to show that there was violation of principles of natural justice. Secondly, such a petition must be accompanied by a certificate of a senior lawyer. If these conditions are not complied with, the court may impose exemplary cost on the petitioner. Limitation. The above remedies are subject to the following limitation relating to armed forces and to the period in which martial law is in force in any area. Number 1. Under Article 33, Parliament may by law determine to what extent any of the fundamental rights shall in their application to the members of the armed forces or the forces charged with maintenance of public order be restricted or abrogated so as to ensure the proper discharge of their duties and maintenance of discipline among them. Under Article 34, Parliament may by law indemnify any person in respect of any act done by him in contravention of fundamental rights in connection with maintenance or restoration of order in any area within the territory of India where martial law was in force, or validates any sentence passed, punishment inflicted, forfeiture order, or any other act done in contravention under martial law in such area. Under Article 359, where the proclamation of an emergency is in operation, the President may by order declare that the right to move a court for enforcement of any of the fundamental rights, except the Article 2021, shall remain suspended for a period during which the proclamation remains in force. Such an order may extend to the whole or to any part of the territory of India, and proceeding for the enforcement of such right in any court shall remain suspended for the period during which proclamation is in force, or for such shorter period as may be specified in the order. When a proclamation of emergency is in operation, none of the guarantees of 7 freedoms under Article 19 shall restrict the power of the state to make any law. or to take any executive action in contravention thereof. Article 358. What is the scope of Article 32 of the Constitution? How far existence of alternative remedy bars application under Article 327 discuss. Article 32 of the Constitution provides one of the most important constitutional remedies. It gives right to move the Supreme Court by appropriate proceeding for enforcement of the rights conferred by Part 3 of the Constitution. The Supreme Court has held in Gopal Das versus Union of India AIR 1955 SC1 that the sole object of Article 32 is the enforcement of these fundamental rights guaranteed by the Constitution. However, other remedies may open to a person aggrieved. He has no right to complain under Article 32 where no fundamental rights have been infringed. In Kochuri versus State of Madras 1959 AIR, the court held that the view that Article 32 is the most powerful weapon in the hands of the Supreme Court of India. With this power, it keeps the legislature and executive within bounds of their respective powers. The power of the Supreme Court to issue writs under Article 32 is a bit narrower than that of High Court under Article 2 to 6 of the Constitution. Under Article 32, a writ can be issued by for the infringement of fundamental rights guaranteed under Part 3, but under Article 2 to 6, writs can be issued for infringement of the fundamental rights or for any other purpose. Thus, the High Court enjoys a wider power under Article 226 to issue writs, order, or direction. Following are the cases in which application of Article 32 does not lie. In Sandhu Singh vs. Delhi Administration, AIR 1965, Supreme Court 9, it has been held that the court will not under 32 interfere with an administrative order, however enormous, where the constitutionality of the statute or the order made thereunder is not challenged on the ground of contravention of a fundamental right. Article 32 of the Constitution is not directly concerned with the determination of the constitutional validity of a particular legislative enactment. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of it, if beyond the competence of the particular legislature, as not being covered by any of the items in the legislature list, but that it affects or evades his fundamental rights guaranteed by Constitution, of which he could seek enforcement by an appropriate writ or order. Chiranjit Lal versus Union of India 1950. Supreme Court in the case of M.B. Kuriakose vs. State of Kerala 1977 has held that a petition to enforce rights under agreement or award is not maintainable under Article 32 of the Constitution. This article is reserved exclusively for the enforcement of a fundamental right. 32 Clause 1 guarantees the right to move the Supreme Court for seeking relief from the court by way of 5 writs as contained in the clause. Supreme Court of India not only issue above writs but also directions, order, or writs similar to the above as far as to fit in with any circumstances peculiar to India, but the remedy must sought within reasonable time. Supreme Court has held in Somavanti vs. State of Punjab 1964 that where the suspension of the fundamental rights has the constitutional protection, Article 32 will have no operation. Supreme Court has held in Somavati vs. State of Punjab 64 case where the suspension of the fundamental rights has the constitutional protection. Article 32 will have no operation. Who can apply under Article 32? Public interest litigation. Traditional rule is that a person whose fundamental rights have been violated has the right to move to the Supreme Court for the issue of writs. But now the court has considerably widened the rule of locus standi and taken the view that any person who has sufficient interest can approach the court for the enforcement of any of the legal or constitutional rights of a person or a group who is unable to go to the court because of poverty or any other reason. Thus, the Supreme Court has opened the door for public interest litigation, which held in Judge Transfer case AIR 1982 149. This has been done with a view to protect justice to those who cannot get it themselves. The new trend can be seen through many cases. For example, Sunil Batra versus Delhi Administration 1980 case, Bihar blending case, SP Gupta and others versus President of India and others case 1982, Bandhua Mazdoor Morcha versus Union of India 1984 case, in Olga Tellis versus Bombay Municipal Corporation case 1986. The Supreme Court has held that a writ petition challenging the removal of huts from pavement on the ground that the procedures prescribed under the law for such removal was arbitrary, unfair, and is maintainable under Article 32 of the Constitution. In MC Mehta vs. State of Tamil Nadu 1991 case, the court held that the children cannot be employed in match factories, which are directly connected with manufacturing process as it is a hazardous employment within the meaning of Employment of Children Act 1938. Another case MC Mehta vs. Union of India 1988, the Supreme Court has issued appropriate direction for the prevention of Ganga water pollution. It directed the Kanpur Nagar Mahapalika to take necessary steps to prevent Ganga water pollution. In Delhi Domestic Working Women Forum versus Union of India 1995 case, Supreme Court has laid down exhaustive guidelines with a view to assist rape victims for their rehabilitation and compensation. In Visakha vs. State of Rajasthan 1997 case, the Supreme Court has laid down detailed guidelines for preventing sexual harassment of working women in places of their work until a law is executed for that purpose. In Nil Bathi Behra vs. State of Orissa 1993 case, it has been laid down the Supreme Court has under Article 32 and 226 of the Constitution the power to award compensation for violation of the fundamental rights by state action. In Subhas Kumar vs. State of Bihar 1991 case, it has been held that the public interest litigation can be filed for ensuring enjoyment of pollution-free water, which is included in the right to live under Article 21. Ninth schedule not beyond judicial review under Article 32. In IR Coelho vs. State of Tamil Nadu 2007 case, the petitioner had challenged the validity of the numerous laws inserted in ninth schedule by various constitutional amendments on the ground that they are violative of the doctrine of the basic structure of the constitution, particularly the judicial review as laid down by the apex court in Keshavanand Bharati vs. State of Kerala. The nine-judge bench, Constitution Bench of the Supreme Court, unanimously held that any law placed in the ninth schedule after 24th April 1973, when Keshavanand Bharati judgment was delivered, will be open to challenge on the ground that it destroys or damages the basic structure of the Constitution. If fundamental rights are taken away or abrogated pertaining to basic feature of the Constitution, the ninth schedule law are subject to judicial review, and if it violates any basic feature of the Constitution, it can be declared invalid. Compensation under Article 32. The Supreme Court has power to award compensation for violation of fundamental rights. Article 32 is not only preventive but remedial in nature, that is, it has power to award compensation for various fundamental rights. MC Mehta vs. Union of India 1987 case and Rahul Shah vs. State of Bihar 1983 case, the Supreme Court awarded Rs 30,000 as compensation to the petitioner in spite of being released by order of the court. Had to remain in jail because of irresponsible conduct of the state authorities. How far existence of alternative remedy bars application under Article 32? Ordinary principle is that extraordinary remedies should be take up the place of ordinary remedies. But since the infringement of fundamental right is viewed seriously by the courts and a speedy remedy is required, the courts do not wait for exhausting the ordinary alternative remedies. Thus, the existence of an alternative remedy is though a consideration for the court, it is no bar for the issue of writs under Article 32 or Article 226 when the fundamental rights have been violated. In KL Kachuni vs. State of Madras 1960 case, the Supreme Court held that the Article 32 clause to itself being a fundamental right and a breach thereof, the court will give relief, notwithstanding the existence of an alternative remedy. Delay or laches. Supreme Court has held that those who seek the remedy under Article 32 after a considerable delay are guilty of laches. It will refuse to grant any remedy. In other words, the remedy must be sought within a reasonable time, but it is what is prescribed. What is the prescribed limit for limitation? What is the prescribed limit for limitation for filing a petition under Article 32? In Trilokachand Motichand vs. H.B. Munshi 1970 case, the court has held that there is no prescribed period of limitation within which a person should get remedy under Article 32. It is the discretion of the court and will depend upon the facts of the case. In Messrs. Neva versus Company versus State of Gujarat 1986 case, it has been held that the existence of an alternative remedy will be no bar to the court's power to entertain petition under Article 32 and to give remedy to the applicant. But adequate alternative remedy must be resorted first. A right to appeal in a criminal case other than a murder is not enshrined in Part 3 of the Constitution. Thus, it is not fundamental in nature. Therefore, an act amending criminal prosecution court as to take away the right to appeal against a conviction in such a criminal case cannot be said to be a violation of fundamental right. So that's all about this video. If you find it useful, like to subscribe.